This is Trump on Earth. I'm Reed Frazier. We've heard a lot about how the Trump administration is rolling back environmental regulations, especially those set by the EPA under President Obama.
My administration has canceled or delayed over 1,500 planned regulatory actions or assaults, more than any president in the history of the United States.
Rules created to address everything from chemical safety to climate change to water pollution have all come under attack by the Trump administration. But that doesn't mean it's getting its way on these issues, at least not in court. Judges have pushed back on Trump's deregulatory agenda in sometimes rapid-fire succession. Today, we're going to talk about those rollbacks and how they're holding up in court with someone who's been fighting them since day one.
We have extensive Excel spreadsheets. We even have an Excel spreadsheet with all of our cases on them so that we can keep track of them all.
Mitch Bernard is chief counsel for the Natural Resources Defense Council, a frequent plaintiff in lawsuits against the EPA and other federal agencies under the Trump administration. And he joins me now. Mitch, thanks for talking with me.
Thanks for having me.
So can you give us a sense of the scale and speed of litigation in the last year and a half? How much action has your organization had in court, and how does that compare with previous administrations?
It's incomparable to previous administrations. NRDC has engaged in, it's approaching 70 cases against the Trump administration since the inauguration. That's around one case every 9 days. We have sued a lot during prior administrations, including both Republican and Democratic administrations, but this is utterly unprecedented. We have added a number of lawyers in the last year in order to meet this challenge. And, we're all working around the clock because that's what this moment demands.
Can you give us a sense of how it's going in court for your side? What has the general reaction been, if you can characterize it?
It's going great in court. That's kind of the irony. It doesn't get reported that much. It is true that the administration is hell-bent on dismantling environmental and human health protections that were built up not only during the Obama years, but before then. But they've done so often in a reckless and sloppy manner. And the courts have rebuffed many of these attempts to rescind and suspend regulations that protect the environment and public health. For example, we have, of our cases, we've had 25 cases that have been finally resolved in the federal courts, and we've won 21 of them.
So why do you think you're doing so well in court?
I think it's a combination of three things. One is the rigor and independence of the federal judiciary. Most federal judges are independent. Number two is we have been particularly active and rigorous about challenging every move that the Trump administration makes in the environment and public health arena that we believe is unlawful. And the third is the reckless, sloppy manner with which a number of agencies within the Trump administration rushed to dismantle established protections in a kind of ideologically driven way.
Let's take for instance here, let's talk about one of the cases that you had some success in. It's a case that your organization brought against the National Highway Safety Administration over fuel efficiency standards. Can you walk us through that case? What did the Trump administration do and what happened in court?
Well, it is an extraordinary case, and it's an example of some of the things that I've been alluding to. Congress passed a law requiring corporate vehicle fleets to meet certain fuel economy standards. There were penalties that the corporate entities had to pay if their fleets did not meet these standards. But the penalties had not been updated for many, many years and were not adjusted for inflation. And they were just basically a cost of doing business and had no bite anymore. So Congress saw that and passed a law requiring NHTSA, which is the National Highway Traffic Safety Administration, to increase these penalties to make them meaningful. So this rule was about to take effect when the Trump administration came into office, and the administration temporarily suspended the rule 2 or 3 times. And then finally, we sued.
We'll turn to our next case, which is National Resources Defense Council versus the National Highway Traffic Safety Administration.
Challenging this move is unlawful.
And the problem that Congress meant to address was this precise situation.
I don't know if it was yours or the NRDC, said many manufacturers find it cheaper to pay the penalty than to comply with the standards.
That's exactly the problem. I mean, just to put it in practical, it's perverse, and to put it in practical terms, the real value of this penalty has been cut in quarter by the intervening years. What Congress intended,
and it was unlawful because it violated the statute that underlies fuel economy standards, and also because the rule was suspended without any of the public notice and opportunity for the public to comment that is essential for, rational rulemaking.
Thank you, Your Honor. May it please the Court, Thomas Byron from the Justice Department here on behalf of the government, the respondents. I'd like to start by emphasizing what we've tried to point out in our brief, which is the insignificance of the delay decision.
These are just kind of black letter law requirements. You can't promulgate a rule like this without giving the public notice and an opportunity to comment. And you can't suspend a rule without doing the same.
You had this congressional mandate to do it by a date certain, and you've just ignored that.
Well, Judge Pooler, I don't think it's fair to say the agency ignored that. So let me talk a little bit
The
about
Trump administration just didn't like that at the behest of the automobile industry, or because the rules had something to do with responding to the problems of climate change. And so they suspended it. And the case was argued on April 12th. The court vacated the rule, the suspension, in other words, restoring the rule that should have been implemented 11 days later. On April 23rd. That is lightning quickness. And so that's both evidence of how lawless the Trump administration has been, and also how strong the courts have been in responding to that lawlessness.
So another case I'd like to ask you about is the waters of the U.S. rule.
It sounds so nice. It sounds so innocent, and it was a disaster. The title is so beautiful. That's where it stopped.
Your organization just had a victory in South Carolina when a federal judge reinstated water protections in 26 states. Can you tell us what that was about and why it was such a big deal?
Well, it is a big deal, but unfortunately, I don't think that victory is going to last very long. The waters of the United States really stems from a kind of problem in the law under the Clean Water Act. And it has to do with what waters are subject to the jurisdiction of the government under the Clean Water Act. This has been a subject of controversy for many years. There's a Supreme Court case on it from years ago that didn't really resolve the issue. The government issued a rule, the Waters of the United States rule, which tried to define what waters were covered. And there was a suspension of the rule by the Trump administration. So what that meant was that it returned to a situation in which fewer waters, streams, tributaries, and the like, were covered by the restrictions imposed by the Clean Water Act. There's a lot of litigation around the country, and there was a case in South Carolina in which a judge invalidated the suspension, which restored a more generous interpretation of what waters are subject to the restrictions imposed by the Clean Water Act. And so in a number of states now, the rule is still in effect. However, it is widely believed that the government is about to rescind the rule altogether. So all of this litigation about whether the rule was properly suspended, and we believe it was not, and the court in South Carolina agreed with us, will give way to litigation about whether rescission of the rule altogether is appropriate under the law. this is an example of something that is very important, I think, for people to understand. There has been a first wave of litigation in response to these rollbacks. And most of the initial rollbacks had to do with failure to implement a rule or suspending a rule pending review by the government. In those cases, we have done remarkably well. But now the Trump administration is going to rescind a lot of those rules. They're not just going to fail to implement or suspend. They're actually going to repeal or rescind the rules. The question after the Clean Water Rule is repealed is whether the repeal is lawful in terms of the substance of the Clean Water Act. And that's a different kind of case, and that'll be kind of a second wave of what we call Trump resistance cases that will be filling our docket in the next couple of years, we expect.
Do you really call them Trump resistance cases?
Well, yes, I do. Look, there are two different things going on here which are interrelated. One is the resistance to the rollback of critical environmental and human health protections. This is a full-scale assault on protections that have been built up over decades to protect the environment and human health. It's across agencies, it's aggressive, it's beyond what anyone could have imagined. But the second layer is this kind of attack on the rule of law, this kind of disdain for law. And the purpose of many of those statutes is to provide meaningful protections for endangered species, for people with respiratory disease, for subpopulations of vulnerable people, to control air pollution and water pollution. I mean, there are reasons behind these statutes. And the second part of that is procedures. You know, when you enact a rule or you suspend or rescind a rule, you need to involve the public. You need to tell people what's going on. You need to give people a chance to weigh in. You need to build a factual record. And the decision you make on the merits has to follow from the facts that are in the record. And those are all very, very good rules. And they keep us from descending into government by somebody who, for political reasons, just comes in and says, well, you know what? I don't believe in climate change. So I'm just going to rip out every page in the rule book where there's a regulation that curbs carbon emissions. You can't do that under the law. Your decisions have to follow scientific evidence. And this administration has nothing but disdain for that. So when I say Trump resistance, that's what I'm talking about too. We are trying to vindicate the rule of law in the face of this all-out assault on it.
So one question I have is, given that the Trump administration has been very sort of successful in getting a lot of its judicial appointments made to date, what happens when the judiciary starts to absorb a lot of these appointments? Does it make it harder for you to kind of prove your case before these federal judges? If, for instance, it's a Trump administration appointee and you're saying that a particular rollback or policy initiative was done illegally?
That's a very good question, and we'll see. I worry about it, but less than many other people do. If a judge is qualified to sit on the bench, by which I mean he or she is rigorous and independent and open-minded, then I think we're going to get a fair shot. If that judge is a conservative on various issues, or is a Republican, or appointed by a Republican administration, or confirmed by a Republican Senate, that doesn't worry me very much. I think when judges ascend the bench, they put on that robe, they understand what their role is, and their role is to be independent and objective. As you move up in the system, in the circuit courts of appeal, and especially the Supreme Court, ideology tends to matter more. Those courts are making law. They're announcing law. They're not just applying it. And so we have, for example, opposed the confirmation of Judge Kavanaugh, which we very rarely do. But his ideology, which I don't begrudge him, but if you look at his decisions, they would be extremely harmful to our clients. For example, he might vote to severely restrict access to the courts for groups like NRDC. The other thing to remember is that NRDC's cases mostly are law enforcement cases. We're holding people, either the government or a private polluter, accountable to the law. There's nothing about that endeavor that should turn off a conservative judge, even if that judge is not a big fan of NRDC.
It sounds like what the Supreme Court does is a little bit less germane to a lot of these lawsuits that you guys have been filing than, maybe a lot of people think.
I think that's right. People should remember the Supreme Court decides about 70 cases a year. Tens of thousands of cases get decided in the lower federal courts. Now, some of them are controlled by Supreme Court precedent, but many of them are not.
I mean, this sort of broader question maybe, is this a good system for deciding how to regulate the environment? I mean, it's, a lot of people don't like the litigiousness of our society. That's just a general sort of overlay. And a lot of the work of the government is being, depending on how you look at it, held up or held back by these lawsuits. So
I would say thank goodness for that. Without the rule of law, where would we be? That is what is making the difference now. The institutions of the country, which are really under attack in many, many significant ways. And the law is one of the major institutions we have. It's one of the things that separates us from other countries, other forms of government. And it's part of what keeps us from descending into a kind of chaos or autocracy. And then when people don't obey the law, that's when you turn to the courts. Because without enforcement, these laws are just statements. They don't have the meaning they're intended to have in the real world.
Let's say there's another president who gets elected in 2020 who has different opinions about regulations than this one. How easy will it be for them to sort of go back on some of the Trump administration's rollbacks or, the rules that they're creating that are more generous to industry? How hard will it be for them to sort of reverse course on some of these laws?
Well, if they do it correctly, it's not going to be so easy. It's going to take time. Because as I said, you have to go through the proper procedures. First of all, you have to decide what you think is the right thing to do and what Trump initiatives you really can't live with or want to refine or revise in some way. And then you have to go through a sometimes lengthy process to elicit public comment and consider that comment. And then you have to put together a factual record and then see where that leads you. So if you do it correctly, then at the very least, it will take time. To the extent the Trump administration succeeds in ripping up sound and critical environmental and human health protections, it's going to take years to repair that damage, even after a new president is elected who wishes to do that.
So in a way, even if they lose 80% of their court cases, they're sort of succeeding in gumming up the works for whoever comes in next.
Well, they're succeeding in part. They've been stymied a lot. They've wanted to change a lot of things that they have not yet been permitted to change. But they do get some things through, and they certainly have big plans. When you look at the Waters of the United States rule or the Clean Power Plan, I mean, these are huge and hugely significant areas of regulation that, if they get their way, will be upended. Undoing that kind of damage will take a lot of time and effort.
Mitch Bernard is Chief Counsel for the Natural Resources Defense Council. Mitch, thanks so much for joining me.
Thank you, Reed.
Thanks for listening to the Trump on Earth podcast. My name's Reed Frazier. All of our episodes can be found on our website, trumponearth.org. If you'd like to support the Trump on Earth podcast, go to patreon.com/TrumpOnEarth. All those who've given, thanks so much for your time. We're going to use any money we get from that to help us directly improve our production values. Like, for instance, this here episode that we just recorded. We're using some of that money today. This podcast is produced by Andy Cubis. Kathy Nauer is our executive producer. Thanks so much for listening. We'll see you next time.